What's up, everybody? Welcome to No Suits Allowed. Excited to have you back here with us. Our guest today, Mark Astarita, securities attorney, partner at Sala Astarita and Cox, and founder of seclaw.com. Mark, thank you so much for joining us. How
Oh,
you
thanks
doing?
for having me. Good, good. Everything's good.
You're well dressed, man.
Yeah.
I'm
I
in,
figured I should wear a jacket.
I'm in a t-shirt. You know? I love it. So we got to ask you, 40 plus years
Yeah.
in your trade, in securities law, how did you even get started in it, and what has kept you in it?
Oh, yeah. Well, getting started is easy. When I graduated law school in the early '80s, there were no jobs. That was the job I got. Was at a law firm that practiced securities law. Best thing that ever happened to me with respect to my practice and my profession. I love it. It's a wonderful field, and what keep me in it? It changes. It changes all the time. Congress, legislators, always coming up with something new, some
Yeah.
new thing to regulate, not regulate. Let's regulate crypto. Let's not regulate crypto. So it changes all the time, and it's always something new to learn and nothing new to figure out.
Amazing. So, I mean, was there anything you were going to potentially veer to in that early? You said this is the job I got, so I took it.
Oh no, there was a lot of veering before law school, but no, no. Actually, I wanted to be a criminal defense attorney is what I was going to do. So I was interviewing with the district attorney's offices.
Okay. And so, I mean, your resume is long. It's too long to go into, but I want to talk about arbitration first. I find it really interesting. You've done, correct me if I'm wrong, over 600
Yeah, it's I
arbitrations.
stopped counting at 600.
Okay. Yeah, I would too. So I don't, as you know, as someone who was an advisor, had a book, I don't think a lot of advisors even understand like this arbitration process. Like a firm or broker dealer, there's a dispute, there's something to be settled. Can you talk through that? Like, can you talk through like like how does it generally work?
Oh,
Like what's you know what I mean on both sides?
sure. Or arbitration. I once told a client that the arbitration. Don't worry, arbitration is less formal than court. We finished after a week, and he said to me, "If you ever tell anybody that it's less formal than court, I'm going to come in here and find you." Because it is less formal. You're doing it in a conference room with 3 arbitrators, not a judge, not a jury, and you're all sitting around a big conference table.
Yeah,
Other than that, it is very much like a trial in court. It's a little obviously a little more informal, but the it's the for I guess for advisors, most of them come up with customer cases or firms, but stick it to a customer case because that's got a little more play in it. The customers sue and they sue for in 600, most of those are customer cases, right? There's probably 500 are customer cases.
okay.
So they sue, they file a complaint like you would file in court. We file an answer like we would file in court, and then we do discovery. So we ask them for documents, they ask us for documents. No depositions, so you don't get to ask the other side any questions live.
You don't.
No,
So
you don't.
you don't get to object. That would be my
Wait,
favorite.
no, that's that. Yeah, no, at the hearing you get to it.
Okay, okay, good.
Before the hearing, you
All right,
don't.
okay.
Right? So you exchange documents, and then you do a hearing. I mean, we're doing it. I have a hearing coming up on a week from Monday, and that's what we're doing right now. We've exchanged documents. We've fought over documents, and the arbitrators ordered the other side to produce documents that they were refusing to produce to us.
Yeah.
We got those, review them, and we do the hearing. The hearing is it's a hearing like you see on TV, except we're sitting at a conference room table,
Yeah.
with 3 arbitrators and no judge. And then those go on. It depends. The broker cases, most of the broker cases are over promissory notes or non-competes or rating. Those go a week. Customer cases, I've done customer cases that have gone 10 weeks,
Oh,
and they don't go consecutively.
Okay.
So you schedule 5 days,
yeah.
and then we get to Thursday, and everybody says, "Oh, we're not gonna finish." No, we're not gonna finish. So now you've got 2 attorneys, 3 arbitrators, X number of witnesses, and you gotta get everybody's schedules together. So if we were doing it in September, and now it's Thursday, we need more dates. Those dates are in February.
Oh, wow.
Wow.
And if you don't get, I mean, we always try to get, guys gotta schedule more dates. Let's get 2 sets of dates in February
Yeah.
as we get this done. And most times you can't get everybody to do that.
Because that's interesting because that then shows pending, right?
Oh, yeah.
Customer.
Yes.
So if that advisor, let's say, is trying to get a loan to buy a book or do something like it could be a flag, it could be a stop.
That shows, in my experience with advisors, customer arbitrations, generally, I don't think are a stop,
Okay.
at least in my experience. Uh, FINRA investigations are definitely a stop.
Different story. Yeah.
But arbitrations, I think it more depends on what the details are and what's involved. I mean, my office, we're doing cases now where the broker's got, I think he's got 8. We're not representing the broker, we're representing a customer in one of
Okay.
those.
Okay.
But there's 8 cases against them. So his U4 or his CRD is all marked up.
Yeah.
I don't know whether he wins them, whether he loses them. Hopefully he loses at least ours. But yeah, so that's a marking your license forever. And those can generate federal investigations as well.
Right. So when you're, let me ask it on this side. So when you're representing an advisor, let's say in a customer complaint, right? And let's say it's unfounded. What advice would you have to all advisors who get in that situation? Because, and I'm going to guess what you'd say, but I'm not going to say it, because they're going in and they might be like, that's made up. I didn't do that. But again, you got to prove these things. So,
Well, the reality is the customer has the burden of proof, right? So the customer has to prove that the broker lied or misrepresented or whatever you recommended wasn't appropriate. But the reality is, as the defendant, we call it, but respondent in arbitration, you have to prove something. You have to disprove what you can disprove. Years ago, I wrote a legal column for Research Magazine, which was an industry publication. And oh yeah, I can write 1,000 words a month, no problem. Yeah, after about 6 months, it's a problem. I have nothing to write about it anymore.
all your openings are just, how's everybody doing? What am I reading?
So but the first column I wrote for them, and the editors do the titles, they titled it For the Record. And the point of that column, and it's still true, is you have to keep notes.
Yeah.
Advisors have to keep notes. I had a group of advisors who were trying to record telephone calls. Okay, you can do that. But can you really? Because what happens is it becomes too cumbersome. Now what they start doing is they record the close. So you've got a half-hour conversation that's not recorded. You've got okay, Mr. Jones, we're gonna put it in an order for 100 shares of Amazon at $30, and then the recording stops. I'm sorry, the customer says yes. That is a disaster at a hearing, because now you get a cross-examination. Well, Mr. Smith, Mr. Broker, what did you not record? And you controlled that tape, didn't you? And you decided when to turn it on, when to turn it on. And then the other thing, I had one broker do this. He says, oh, I have recordings of this customer. I recorded all my calls to them. Oh, good, give me them. He opens up his desk drawer. You know the bottom file drawer that you have in your desk? Yeah. Now picture it 3/4 full of micro. And he's like, wait, I'll find it. And he shoved. What are you doing? That's worse than not having the recording. Because now you recorded the customer and you destroyed the tape.
And you just sort of,
Obviously you didn't do that, but that's about. But notes work. And today with Echo, I used to use Echo, right? There's all these computer programs that you can keep notes of your calls and keep them in some organized fashion. And yes, they're self-serving, and yes, you recreated them, but you created them contemporaneously, and they have weight at a hearing.
Yeah. So I'm hearing notes.
Yeah, notes. I mean, I think we all as managers at some point in our financial services careers have been the one sitting at the desk with the advisor, be like, got to take notes. Why aren't the notes in the CRM? But the notes in the CRM. And they're all, and sales guys by nature hate admin work. Hate it.
Of course, everybody does. But you know what? When you get sued for $1 million,
Yeah.
be nice having notes. And so you can say, you don't even have to read the notes. But you know what? On September 15th, I spoke to the customer and I told him, and the notes don't have to be full sentences. They just have to be things to jog your memory and to document that I did have that conversation. And you got to make sure that there is phone records that go along with it. Phone records have changed over the year now, but we don't have as many as we used to. But the brokers, that's the other burden, is to show that you discussed it with the customer. You had a phone call with the customer before the order went in on that day. That's a new one.
That's a big one.
I had the conversation. Well, we spoke about it. When did you speak about it? Last week. Nope.
I had a conversation with an advisor who got termed saying, oh, it's a misunderstanding. It was my friend. I placed, he gave me the instruction to place the order, but I waited a few days.
Nope. You just use discretion.
That's it.
Yeah, you can't do that.
Yeah.
It's ridiculous. I've done a bunch of those, and a lot of times it's ridiculous. It's my friend. It's my next door neighbor. We spoke about it, and he told me to wait. Okay, you can wait. You need that in writing.
Document that too. Yeah,
You need written description.
exactly. Well, I remember we were talking too about prom notes, promissory notes, and yeah, and I'll tee it up this way. So, what's your take on advisors who think they're going to get out of them?
You're not.
There you go.
Yeah.
You're not getting out of it. I mean, I've gotten advisors. I had an advisor in California a couple of years ago, $1 million left on the note, got out of it. That's all she got out of that, though. They canceled the note. We had a $5 million counterclaim. She got nothing. I think she ultimately went bankrupt.
Wow.
So yeah, and
What reasons are you seeing advisors saying, I release me from that? Because it doesn't really make sense. It's usually pretty clear. Stay here for 7 years, stay here for 9 years.
Well, not only that, but I have a bunch of advisors who are saying, "Hey, I think I'm gonna get out of it, or I'm gonna leave a year." The one who's like, "I'm gonna leave a year early, and it's only 150 grand left." Are they really gonna come over at me or
Yes.
for 150 grand? Right?
Yes.
Yeah.
Yeah. I don't care what firm it is.
Yeah.
They all coming at you for that last year. And you also got to be careful. This goes to what we do in the beginning with advisors when they're transitioning. But you got to be careful what that note says. Notes, at least in my experience, and again, I don't deal with the universal broker dealers. Usually, a lot of times at least they used to be, they were forgiven on an annual basis. That is the worst, because a broker's going to leave at month 10 in his 3rd year, and they're not going to cancel the whole year. So what we do now is depends on the firm, and you don't have a lot of leverage. You get them to be done
Monthly, yeah.
and then but getting out of a note, the promissory note is an unconditional promise to repay. You're not getting out of it. I've had brokers say, "Well, they promised me a corner office," and I'm not making it up. This guy said this thing.
You know Eric's case. Okay.
It's like, okay, no.
So he wanted to get released of the note because he.
No, that was you wanted to part of the note down. And you know what? They changed my sales assistant 4 times. Okay. Who was paying for the sales assistant? Oh, the firm was. Okay. You're not getting out of $1 million note because you didn't get the corner office, you didn't get the office you liked, and you didn't like your sales assistant. So my manager changed. The guy who hired me left right after I got there. That used to be a big one. I haven't seen that in a little while.
Yeah.
So you're not getting out of it. So if you've got a good counterclaim, the answer is to pay the note. Now, obviously, some producers can't do that. So they just don't have
Spend the money.
whatever it is.
Yeah.
Oh, they spent it already.
Yeah.
Oh,
Sure.
We see that one, and they're like, "Hey, I got to transition again." Right? They're forcing the
yeah.
transition to go repay. Yeah. Oh wait.
Yeah.
Right.
But they listen. They spend the money. It's tough if you're getting $1 million in a check. Or I mean, I've got guys that got 10 million.
Yep.
That's very tempting to. I had a client who got, and I'm not making this up, him and his partner both got $15 million. They both took that check and put it in a cash reserves account at Fidelity. And they took out I think whatever years they were on, 7 years, they took out a 7th every year. So if it never came down to it, now obviously these two were big producers. They had a lot of cash to begin with, so that didn't need that 15 million to carry them through the transition. But they're like the only ones.
I was gonna say that's like the.
The only ones I ever saw do.
I tell most advisors, like, "Hey, go put it in the money market, get your 4.25%, take a 7th out every year as you get taxed, and let's make sure that we have it options when we're going to the next firm." Right?
They don't do it.
Never, not a single fucking time.
I know they don't do it.
Yeah, but they say, look at this car I got.
Yeah, the amount of texts I get like a month after transition of boats, cars, watches, houses, them flying on a private jet to Turks and Caicos. It's every single time because we have good relationships with the guys. We transition, and next thing you know, you're getting a text become friends over 9 months, right? You get a text like, really?
I mean, I get it. You got that check for whatever the number is. That's nice. That's cash. I can put it. I'm going to spend it. You're tied up for 7, 9, 11 years. We're seeing 11-year deals.
I saw
11.
I've seen 14.
I think UBS.
Seconds.
I think UBS just launched an 18.
Oh, come on.
Yeah. I'm like, how? And they're like, the only requirement is that you're alive. Well,
I see. I'm 40.
18.
let's
That's crazy.
talk about that. Have you ever had anybody? What happens? I think it's a good one. What happens if you do pass away during your promissory note?
Depends on the firm.
Yeah.
It depends on the note. Some forgive it, some don't.
Mm-hmm.
I mean,
Yep.
I don't think I've done one with a representing an advisor who's transitioning, where it didn't cancel on death. But I have seen them after the fact when when the firm comes after
Mhm.
them, they're coming after the estate.
Yep.
Well, the answer to the firm is, "What are you doing? The
Yeah.
guy died.
Yeah.
Take the
You're
book
coming after his wife, right?
and take the
That's
book.
what
Call it the
you,
thing.
you got his book,
Yeah.
and you didn't pay for it.
Yeah.
So,
So that is, I saw one of those live, unfortunately. So a couple of years ago, helped a guy join Ameriprise in Florida, and he was like a super fit guy, and then all of a sudden, literally, so he'd signed everything, he'd done everything, he's coming into the W-2 channel, and then somewhere 9 to 12 months later, like stage 4 brain cancer, and he's gone within like 3 months. But they did have the policy of we're gonna just release you of it.
yeah, most
So his wife and
that's
all that,
precedent.
and then they even did a buyout of the practice. Like they handled it super well. So like, but to your point, that's all firm specific. That might be,
Well, that
you're
is.
gonna have to read that. And
But I really, and again, the ones I've done up front, I haven't seen one that wasn't canceled on death, or didn't say anything.
Yeah.
Not saying anything's okay too. But from the firm perspective, for firm clients, what are you doing? You're going to go sue the man's or the woman's widow, his children?
Yeah.
Yeah.
Right.
You're not going to win.
That's
You're not going to win. You're doing that in an arbitration. Arbitrators are never, ever going to grant that.
yeah.
So I think that's a good transition. So you see, how many advisors do you see not getting their note read by a lawyer? They just go and DocuSign when to sit and they sign it. How often does that happen?
know.
I can tell you it happens all the time.
For sure.
Every time, I would say probably less than 50% of the transitions I do, they have an attorney look at their note.
Less than 50?
Less than 50%.
Well, you need to fix that.
Yeah. And you could tell them all you want, right?
Yeah.
You can send them an attorney, but they get there and because the note paperwork, half the time, they won't provide it before.
Right.
You actually sign.
No, you're signing that you're there.
Yep.
Right.
That's right.
That's another problem. And you can't fix that problem.
Yeah.
They're not giving that.
Yeah.
Most of the firms are not giving you the documents before. You also, in the transition, you have difficulty and issues with doing that before you get there, right? Because now you've got fiduciary obligations to your old firm.
Mm-hmm.
And you still have them to your employer, as we all do. I mean, when I left my old firm, I hired a lawyer
Yep.
because I was concerned that I wanted to make sure just somebody away from me. I know what they do. I know not to contact my customers to tell my clients I'm leaving, but brokers don't do that,
No.
and I'm not surprised if half of them are reading.
Yeah. What's your biggest advice then in transition, right? Because we talked about that casually, like,
Yeah.
and this is obviously what we're doing all the time. You get an advisor, they've accepted an offer. Now here comes that 4 to 6 week prep before they go, which again, now you're talking protocol, non-protocol, but just bigger than that. Do they have an attorney helping them? Do they have some advice? Like, what are you seeing or what have you seen in terms of mistakes people are making in that process?
Yes. Biggest mistakes, and also is 4 to 6 weeks enough? Because I would argue that they should have an attorney the minute they start deciding that they're going to leave. They should have an attorney ready to go reading their employment contract,
They
especially the
should.
wirehouse advisor.
And they should find a copy of their
Yeah.
current employment contract. I can't tell you how many advisors say, "Oh, I've been there 5 years. I don't have."
Right.
I need to see that agreement. I need to know what you agreed to about soliciting customers and moving and all of that. So that's most advisors have it, or they can grab it. So I had one guy years ago. I'll get it from the firm. You're not going to ask the firm.
The second you ask for your employment agreement, they know you're gone. Yeah.
Yeah.
So,
But I'm just doing the files in my house. I get,
yeah. I'm missing the done. That doesn't work. And I think I only recall one guy doing that. But the you up front, but nobody does that. Then it's not only advisors, it's everybody.
Yeah.
Yes, should you hire me and have me review that agreement once you decide that you're going to go, or once you're having the conversations that you're going to go. But nobody does that. They come to me at the last minute. What else should you do? You can't tell your customers you're leaving.
Yeah.
And you should not tell anybody at the firm that you're leaving because, I always say, if you're going to commit a crime, don't have a partner. Commit a crime by yourself. Think about it. All criminals that get caught had a partner or had somebody else involved in that crime. And that, not saying the brokers who advisors are of the many crimes. But you can't tell anybody.
Right.
I mean, maybe obviously you got to tell your team because your team's going to go if your team's going with you. But that's it, and you cannot tell clients.
It's wild that, well, as delicate a process as it is or can be, because to your point, you're keeping these things inside you're kind of doing some prep and hopefully within the rules and all that. But it's amazing how many people do start spreading the word. They do take whole client files and data and
Stop
yeah.
downloading firm documents.
Yeah.
Oh, they'll never know. Dude, they know everything you did on that computer. Everything. And that photocopy machine that you used, they know everything that was done on that. And there's copies of the documents you copy in the photocopier. Oh, but it's okay. I'll just take a picture of the screen. Okay, sure. Knock yourself out. You just said somebody do that. Send me
I have that.
I love it.
I have that one.
They sent me a
on my-
picture of the screen.
I love it.
You still took a document. Maybe they can't prove it as well, but I had a guy do it. He was on a Zoom call. How do you know that nobody else on that Zoom call recorded the Zoom call, recording you doing this with your phone?
Right, right.
What are the biggest mistakes you see? You see people telling people they're going to leave, telling clients they're going to leave. What are the other biggest mistakes you see people making?
Yeah, I don't see that too often though, telling clients. I think most employees, brokers included, understand that you can't tell clients. Taking documents or thinking of being very clever about how you're going to take those documents. And the reality, if you're in a protocol firm and going to a protocol firm, you don't need those documents. You'll get them all eventually, right?
Yeah.
You do the protocol, you put together your list, you leave the manager of the list. Here's a crazy story.
I know this one.
I sat down with a team and they insisted on meeting in person. Most of my clients are all over the country, so we don't meet in person, but now we got Zoom and yeah, fine. These guys were in Florida. They wanted to meet. Fine, we meet. We got three or four of them in the office. We're in a conference room. And I'm sorry, it's torture for me. You just fine. You know what? Send me an email with your questions. How about we do that? Because I'm charging you by the hour. So anyway, we sit down. We go through the whole protocol. They're going protocol to protocol. No problem. And I give them in writing what you can take. It's not real complicated. Name, address, telephone number, name on the account. You cannot take the account number. Do not take the account number.
Yeah.
But you have to give your manager the account number. So create a spreadsheet, knock out the account number column. Do not save that. Print it out or wherever you're giving it to your manager and give it to your manager. And that's the whole protocol, right? That's done. Do that 4-man team. About 2 weeks later, Mark, I got a call from my old firm. I didn't leave the copy of the spreadsheet with the account numbers on it for them. So they asked me to send it to them. And so I sent it to him. Is that all right?
That's so good.
No, it's not
all right.
You moron. What are you doing? So,
Yeah.
and you know what? Because the scary part of that, nothing happened.
Really?
They had him dead to rights of either than the
If
program.
they wanted to. Wow.
Now, that firm also, I did a couple teams transitioning away from there. They didn't go after anybody. So that had to be a business decision by the firm.
Right.
And everybody, I had so many transitioning because the firm was not good for the brokers.
That's amazing. So I wanted to get your take on, let's put you in the prediction seat, like the future of the industry, right? Independence, RIA, if just your take on all the work you've seen, not only with the regulators, with these broker dealers, like what would you predict in 10 years from now this landscape looks like?
I told advisors years ago to go independent. It's, but not everybody can do it.
Right.
Right. If you're going to go to an RIA, you can't get transaction-based compensation.
Right.
So for a lot of guys, that's a deal killer.
Yeah.
I think you're going to see more and more independent. You now see these, what are in reality, OSJs are big firm.
Yep.
But those OSJs are now, they're basically mini brokerage firms.
Right.
Yeah.
We used to represent, there was 6,000-7,000 broker dealers years ago. Now there's 4.
I think there's 800. Like it's not that many.
No, it's more than 4. Or whatever it is.
Yeah.
My point was they don't count those little OSJs anymore. Or they never did. They're not broker dealers, right? But that's the way people were going. So you have your own shop, your own deal. You run the people. You get paid the commissions from the BD.
Yep.
And for most advisors, it works out very well because that's a lot of people, want to be independent. I hated working for somebody. I was a partner in a law firm for a long time. I had 5 partners, which is kind of like being married to 5 people.
Yeah. Yeah.
And when I started my own firm, it's being a partner in a law firm is great. You get that independence, and I always wanted the independence. And when I went smaller, I got more independence. And now I do what I want to do. I'm also at a different point in my career. I'm not 35 years old coming
Right.
out, you're starting out of law school. So I think that's going to be be prevalent, and you see that expanding. And then the problem with ugh, FINRA and the SEC. I mean, I also deal a lot with more with FINRA. Although I just got a client has an exam, a broker dealer client has an exam from the SEC, which is the number of documents that it's kind of standard, but it's
Mhm.
just outrageous. But it's usually not the SEC. It's FINRA. If there's a rule violation or some type of investigation, it's usually FINRA. FINRA and the SEC I have an issue with them because they're very I using the word independent. The SEC used to be until recently, until this year, the SEC enforcement attorneys can decide what cases to bring.
Mm.
No oversight. Now, these are not kids. These are not newbie lawyers, but it's still one lawyer deciding what case is going to get brought,
Yeah, wow.
and that is significant to the advisor. I just represented a hedge fund. I'm still representing them. In an SEC investigation, 3 years of investigation,
Mm.
3 years they filed in federal court, 3 years of litigation in federal court for us to resolve it the week before the trial started.
Oh, wow.
Which I tried to when you do those, I try to settle them up front.
Of course.
Sit down. We met. Sit down. Show me what you got. Of course, they won't show you anything. They just tell you, and they want an outrageous number. Crazy. We settled for less than 10%, but 6 years of
Yeah,
litigation.
yeah, I was gonna say.
That's the
Do
problem.
you feel like that's, we're almost out of time, but do you feel like that's a little bit of the MO is like, well, hey, we've got capital, like
Oh,
we'll
yeah.
we'll ride this thing out. We got time. Yeah. Yeah.
FINRA and the SEC both. They don't have any overhead. Oh, I'm sorry. Well, they don't have. They don't. There's no cost to them.
Yeah.
In their heads, obviously there is a cost. The last FINRA hearing I did, an enforcement hearing for a week, they come in with 5 attorneys. Me and my paralegal. Now I won. Actually, we lost at the enforcement hearing. I filed an appeal. But another one you can't afford. You can't afford any of this. You don't do any enforcement hearings anymore because nobody can afford it. This guy could, but he couldn't afford the appeal. I said, you know what? This is so wrong. You pay me when you can. We did the appeal, and you're appealing inside of FINRA, right? You're appealing the IHC.
Right.
They throw everything out. Home run.
Wow.
Home. They dismissed the complaint. So he's like, I think I need to pay you. I said, yeah, okay, but you pay. I said I would do it on a calm kind of. So that's the real problem is the expense of all of it.
Yeah.
And enforcement's not going away, obviously.
Yeah.
So that's the problem is keeping good records, understanding that the last thing I've had guys. I don't need a lawyer. I didn't do anything wrong. Well, the customer says you did. Well, I didn't do anything wrong. I'll take care of it.
Is
The self.
Okay.
I think one of the big things that, advisors struggle with is that they live in that black and white. I didn't do it, or it's unfair, or this or that, right? Like they get really stuck in that. What advice would you give them if they're going down the road of a complaint or going into arbitration, that a mindset shift they should have of, hey, from this isn't fair, or I didn't do it.
Well, get over this isn't fair.
Mhm.
It's not.
Yeah.
Right?
Life isn't fair.
Exactly. He's just gonna say that. You're getting sued. It's not fair. No. And the process is terrible. The arbitrators are against me. No, they're not. The arbitrators are 3 individuals, 1 lawyer, 2 people, 2 other people. They're not against you. So get over that. And then listen to me. I'm doing this for 40
Yeah.
years. I've done it all. I've said, now, I shouldn't say I've done it all because people are very creative with what they do. But I know what I'm doing.
Yeah.
My partners know we all know what we're doing.
Trusted advisor. It's the reason clients go to financial advisors, right? How ironic, Well, this was great, man.
That was
Thank you for doing it, Mark.
Oh.
Mark Astarita, secclaw.com. Check that out because you started that site, right? It's still out.
June of 1990.
June of 1990.
Yes, it's still going. Updated almost daily.
I love that. Thank you for doing it.
Thank
man.
you.
This was a pleasure.
All right, thanks, guys.